you know, I have it on the speaker with my husband here, and I also put this in a recording line.
Okay.
Okay.
Great. So I apologize for just now getting back to you guys. I just heard back from the client on this, and I've actually been kind of going back and forth with them to get to the bottom of everything here. And so basically what I got back to them, I got the updated balance and then an explanation on the terms and conditions on the 60 cents per pound claim. Can you hear me?
Yes.
Okay. So basically what they explained to me is that if you look, I guess at the back of the document that you signed, there's a section 8 titled the filing of claims, and on that, I'm looking at it upside down. I gotta rotate this so I can read it. So section 8 here says, basically, where a claim is not filed or suit is not instituted in accordance with the foregoing provisions, carrier shall not be liable and such claim will not be paid. All claims are subject to the full payment of services rendered by carrier. So they highlighted that, and they said that that's why the insurance claim was never processed or submitted, or I guess it was submitted but it got canceled or what have you. But basically they're saying that even if there were damages or what have you, you would have had to pay the full balance and then been reimbursed by this third-party insurance company that amount of the 60 cents.
So let me, this is Edric Caballero. Let me tell you this. They were always in receipt of full payment of funds from the very beginning. We paid them cash on arrival for the remainder of the balance that was owed. So they have always had all of their money. It is they that have failed to deliver on the contract. And it is because of that that we disputed the charges, because they didn't respond to our attempts to resolve it directly. So this is, they're just...
Yeah, what they said was, it says that you, it says client, meaning you Services Caballero, have paid a payment of $1,638.75 plus a 4% surcharge totaling $1,704.30.
We also, that, are you talking about the original amount when we they picked up the furniture, or?
Oh, are you talking about?
Yeah, I apologize. I'm just reading what they sent to me, basically hoping this makes sense to you.
No, they've been dishonest since the beginning, and it seems like
Chris,
it's continuing.
How much they said that we have paid them again?
It says client has paid a payment of $1,638.75 plus 4% surcharge, so you paid a total of $1,704.30. And then it says the fee I have added for the dispute fee for 20% on top. So the final amount is $2,045.16, which $1,284.30 has been paid to us. We are now needing to collect $760.86.
No, that's incorrect. That's incorrect. I think
they're playing lots of games with numbers that don't even exist.
Yeah, I didn't.
And the $1284.30 that has been paid, you guys disputed, right? And had reversed whatever with the
we didn't.
Is Blake there? Because he's the one who we spoke to originally, and I'm getting really tired of saying this story over and over and over. I know you don't know this, but I run a very successful multi-million-dollar company, and I don't have time to talk to a collections attorneys every other day explaining an hour's worth of conversation over and over. So if you can get Blake on the phone and we can pick up where we left off, that would be great, because this is getting ridiculous. Every time we talk to somebody from your firm, they've changed the numbers from the other end, said we made payments that we didn't, said that terms that exist that do not exist, and are contradictory within the contract itself. As you can see, we paid them in full and they failed to deliver the insurance. So there is no reason to believe that if we pay them again after having had to dispute it for their failure to deliver and breach a contract, that they would then honor their agreement now.
Yeah, we spoke
Gotcha.
with.
No, I apologize for the confusion. This is Blake.
Okay. I'm
Okay,
sorry.
I'm
I thought
sorry.
it was someone else. Okay.
Yeah, we go. I said that I was Chris Adam. Like, we go by aliases. Obviously, being collections, we fear for our lives sometimes. So we go by aliases, and somebody gave you my real name, which is Blake.
Okay. All right. I apologize then. But basically, in short, these numbers are not accurate. And as we discussed last time, we have paid in full. They had the opportunity to make good on the contract, and they breached it. And there will not be any payment to come to them until they pay the insurance, at which point we will then owe them because they will have fulfilled the contract that we have not paid for. But at this point, they breached the contract. The contract is null and void. We owe them nothing from this point forward until they make delivery upon their promises.
Blake, I'm not sure.
No, I told you I'd get with them, and well, I'm sorry, what was that?
Yeah, this is Christine. Wing Jen, but if you record the last time when we have a conversation, we have told you that it was untrue that they told you guys that we paid them $1,000. That is incorrect. I think they're just making up number and realize they got caught and try to take it off. But anyway, I'm not sure they give you the update information. They have responded to Wells Fargo. And Wells Fargo now is bringing this to technical court, which have basically Wells Fargo have told me that their lawyers said that their information is not substantiated enough, and basically they have failed to render service.
Yeah, Wells Fargo has ruled in a technical court in our favor because they requested, upon response from Texas Movers, documentation to substantiate their claim against us, and they failed to provide substantial proof.
Well, they give them all the document, but the document is not substantiated
Correct.
enough.
Yeah, so they gave the documents, but the documents did not substantiate the claim that they're making.
So now it has been escalated into a technical court, which you probably understand better than me. But anyway, in short, that Wells Fargo have recognized that Texas Mover Group has failed to render services. And we're going to move forward with this dispute. And
it's worth noting that they have changed the dispute from, what was it?
Well, originally, when we filed the claim, we have told them specifically that what's going on, just like we explained to you. And somebody in Wells Fargo had made a mistake and put the reason for the dispute, it's quality of service, which now have been changed to fail to render services by their technical department.
So basically, it's a determination within Wells Fargo's legal department that they have actually failed to render services, and that is the reason for the dispute. And they have provided documents to substantiate their claim, and Wells Fargo thus far has ruled that they have not provided adequate proof that anything is owed based on the services that they did not deliver. So, I mean, this is, it's getting complicated and it's getting ugly, but I think you'll see in the end that your client is just a fraud. They will pull any number they can to make any sense of what they already submitted and tell you whatever they want just to get you to collect from us.
You know, it's very easy. They told you that we owe them $2,000, whatever number it is, and they told you that we pay. Ask them for the receipt of the transaction that we pay. I will guarantee they won't be able to come up with it because they were just lying.
So whenever they moved you guys at the completion of the move, you had paid everything at that time?
Yes, we did. We paid everything.
They had 100% payment for at least, 30, 45 days until they said that they weren't going to fix the glass. And then, because they had promised for that.
Or offer the 60 cents a pound.
Well, these were separate. And as you'll hear from the recorded call we had from the gentleman that we had conflict with from your firm last time, which got us in contact with you originally, they committed to go ahead and pay for the glass. Again, many times they've committed to pay for the glass, and they said, we'll pay for the glass, just pay us the remainder of the balance, and we'll pay for the glass and then process the insurance separately. I mean, we got recording of your guy saying that that's what your client will say, which is what they originally told us until they found out the glass was $1,000 and then wanted to go through insurance.
But the remainder of what balance? Did they bill after you paid 100%? They billed you, or
no. I'm remainder of what balance? I'm sorry. No, we paid everything in full. They had everything paid in full for 30 to 45 days while we were trying to get them to make good on their promise on the glass. Because the glass was broken, if you recall from our first conversation, the glass was broken before it ever left Texas, which is why they said that they would replace the glass separately.
And then they broke the desk too, and you didn't even have them move that, right?
No, they broke desks that we did have them move. There were several desks.
Oh, okay.
One was a very expensive, irreplaceable, and well, they're all irreplaceable, but this one was a European antique. And so we moved that ourselves and 2 other large pieces of furniture. Now, despite that, they still came to our house and said, we're not going to move you unless you pay another $400. The guy who came here made a mistake, even though it was a firm and binding quote that we signed and they signed, and there was a representative who visually inspected everything. On the day of the move, they changed their story. They broke that contract. They said they wouldn't move us unless we paid an extra $420-something, even though there were 3 large, very large pieces that were removed from the list. So you figure it out, how they're moving less and they're charging us more. Now, if you look online, just for your own reference, you'll find that several other people have commented on Google and other places. It's basically a tactic. They give a quote, they show up, and they won't move you on the day of the move unless you pay an extra X number of hundreds of dollars.
Yeah, it kind of puts you in a rock and a hard place.
Yeah, and so obviously
like
we
switch.
yeah, it's a situation of distress. We had to be out that day. And they, on the spot, said, no, I'm going to pack up if you don't pay us the $400, $420-something. So, okay, that's the only way forward. So we take care of that. Basically, it's an overcharge. We tried to discuss that with them later, and they would not budge on that, but we were working with them on the glass, so we figure if we get the glass, we won't worry about it. Then they dropped the glass when they found out that it was $1,000. They said, you know what, never mind, we're going to go through insurance. So they just keep basically serially breaking promises and lying. And so when they did that, we said, you know what? They overcharged us. This is ridiculous. We disputed the overcharge of the $400 with Wells Fargo because we had already discussed it with them separately, but there was, obviously no resolution. They weren't even going to pay for the glass. So we disputed the $400.
You disputed the $400, so is that the remaining?
No. The $400 is the overcharge that they charged us on the day of the pickup.
Okay.
And they had 90 days to respond to that dispute with Wells Fargo, and they didn't even pick up the phone. So we were ruled in our favor for that $400 overcharge, which I'm sure you'll agree was rightfully so, considering the tactics that they were using, and they're basically illegal, and they broke their binding quote, which we have proof of. Now, once we disputed that and it ruled in our favor, we got an email a couple days later from the insurance company who we had submitted the glass and the desks and all the information and pictures to.
We didn't submit the glass either.
Oh, I'm sorry, we didn't submit the glass to the insurance, but we had submitted all the desks that were broken and pictures and proof and evidence of everything, and the claim had begun to be processed, but a week after we were awarded the dispute of the overcharge, they stopped the claim, and the insurance company told us that Texas Movers has canceled the claim and said that they will handle it internally. No contact from Texas Movers Group. So time goes by, we keep waiting, no communication. So I told my wife, you know what? They're in breach of contract. They haven't delivered based off of the insurance requirements at a minimum. There's many layers of breach of contract and deceit and fraud. But this one is so much so that it null and voids the entire contract. I said, dispute whatever we have on the credit card. Now, keep in mind, they've already been paid how many thousand in cash?
$1,700 in
Nearly $1,700 in cash. So they are not without
Okay, so
money
they're-
for this compensation, or for their
And so
troubles.
that 1,700, that doesn't include the 400 that you disputed on the credit card?
No,
No,
that's separate.
that's separate.
That's already been awarded and
Okay.
done, and it's over with. But anyways,
All right, forgive me. Obviously, like you said, there's a lot of stuff going, a lot of moving parts here.
Yeah.
So anyway,
Okay,
I mean,
whenever they came and delivered the stuff, or when they came to pick it up, you paid them cash before they even moved anything?
They
And
wanted
then
cash.
The remaining 400 on the credit card?
No,
I'm
no,
guessing?
they wanted cash in advance. So we weren't going to do that all in advance. So we paid, what was it, half?
I pay half on credit card
Half on
charge.
credit card, and the other half is due payable in cash upon receipt of the goods before they're even released to us and unloaded. So
So
we paid cash
when
when
they
they
come to-
delivered all of our furniture.
Furnitures.
They would not release. They wouldn't start unloading the furniture without us paying them cash, and we paid them cash.
When did you pay the additional 400?
No, there
no,
was
I
no
didn't.
additional the 400 that they overcharged us was on the day that
Right.
they picked up the furniture. So a week before, we had called them. They had come to the house. They had given us a firm binding quote that listed every piece of furniture on the quote itself. They signed it. We signed it. Basically a contract, short of pickup and payment. When they came to pick
Is that
it up,
when you paid at that time?
no, we paid when they came, the date of pickup.
The date of pickup you paid in
We
In
paid
credit
in
card.
credit card, half in credit card, and then the other remaining half it's upon delivery of the furniture in California.
And so that initial payment, you only disputed $400 of that amount?
That's
Initially
Was
correct,
it-
because that was the overcharge that they basically pinned us under. They defrauded us. They moved less furniture and charged us $400 more.
So basically, all of this.
I didn't know you could. I thought when you disputed something on your credit card, I didn't know you could dispute a portion
Oh,
thereof.
yeah, you can.
Yeah, no, you can
yeah.
dispute any portion that you feel was not accurate, and we know that they moved
Okay.
us, so we tried to make good on the commitment, and we said, you know what, they only overcharged us $400, even though it was excuse my language, it was a shitty practice. We only disputed the $400, and then they came back and said, you know what, we cancel all the insurance then. And as we discussed before, they committed to replace the glass, which was almost $1,000, $900 something dollars, and we had several, probably about, I'm guessing, 2,500 pounds worth of
3,000.
furniture, 3,000 pounds worth of furniture that's been damaged. So you multiply that times 6, you're talking about $1,800 worth of insurance plus $900 for the glass, over $900. You're talking about $2,700 that they are withholding from us. I'm absolutely not going to pay them for what I'm disputing, especially considering
Right.
they had the money and the opportunity to make good on the contract to begin with. I had to take the money back because they were not delivering on their commitment.
Okay. Oh, all right. So make sure I understand. All right. So when they came to move you, you paid half of it with a credit card, and then you paid the remaining in cash once they delivered everything.
Correct.
And then how many? Once you got delivered, how long until you disputed the $400 immediately, or was that?
No, it's a long time. Basically, I wasn't even going to dispute the 420 to begin with. They said they're going to replace the glass. And they sent a glass company, a vendor, to come to my house and measure the table and everything. That alone took a few weeks. And then once they find out how much it cost, they said, I'm not going to replace the glass. You go ahead and submit insurance.
So we were already almost a month behind.
To be honest with you, I wasn't even going to dispute anything to begin with. They just have to make good on the delivery of the glass. That's all I'm asking for. And they failed to do that.
Okay. And then where did the other payment, the $1,284.30, come from? Was that half? Was that the rest of that?
That's
after the
correct.
400,
Yes.
or?
Yes, that is the remaining balance on the credit card charge after I dispute the 420.
Okay.
So
Now,
if,
okay. it's
yeah,
all
if I ever owe them anything, that will for the 1,200 someone I don't know the exact number, the remaining balance of the credit card charge after the $420, that will be what I owe them after they cancel the insurance. I did not dispute until they cancel the insurance. At that point, they left me with no choice. because they have failed to deliver the glass, and now they have failed to provide the insurance service, which is part of the contract.
Yeah, when they canceled the insurance, they became in full breach of the contract.
Right.
Before
well,
that,
of course, they're saying when you didn't pay those, or you, I guess, disputed the 400, that wasn't payment in full, I guess is what they're saying.
Well, but that was because predicated on a lot of commitments that they broke to us. Verbal commitments to replace the glass, and they made that same commitment to you guys to try and collect from us. If you pay us, we'll replace the glass. We've heard that story before. We're not fools.
But anyway,
but you said that's already been resolved now, or you got the glass has been replaced.
Right, but anyway, if you want to
Yes,
get
that's
full
correct.
information, you can contact, I believe the name is Justin. Well, if you call a website called Thumbtack, that's where I found Texas Mover Group. We actually got in touch with Thumbtack when Texas Mover Group refused to replace the glass. So we got in touch, we get a contact. We contacted Thumbtack and said, one of your vendor, Texas Mover Group, had been breaking contract over and over again. So they actually got involved and tried to resolve it. And Texas Mover Group have stopped responding to them. That's when
So they got blacklisted or something like that.
That's correct. Yes.
That's correct.
Yeah, so they have a very, you can see there's a month's worth of track record of them making promises, breaking it, signing contracts, not delivering. I mean, all sorts of stuff. It's endless with these people. But as you can see from the math I've given you and the conversations we've had with them and the commitments they've made, they owe us somewhere between $2,200 to $2,700. And they're trying to collect from us
$700.
I don't even know how much, but it's not even half of what they owe us. So like I told you before last time, if they process the insurance, because right now they have zero claim against us. If they process the insurance and fulfill the contract that they have obligated to, then that will obligate us to have paid for the services rendered. At this point, we're at a standoff. They don't provide, they don't consummate their services, we don't owe anything. And we're certainly not going to repay for something that wasn't delivered in the first place. I mean, they had the money, they had the opportunity to make good on it, and they didn't.
So like you said, it's pretty much a standoff. You know, I guess it looks like it. From what I understand, it looks like it's stemming from that initial dispute of the $400, and they canceled your claim because at that point it wasn't.
Well, it actually doesn't stem
payment.
from that. It stems from the broken glass that they committed to replace. Had they replaced the glass, you know, like I said, I'm not trying to be flashy here, but money is not a problem for me. I mean, a couple $100 doesn't matter to me. But this is principle.
Right.
I'm not going to go paying thousands of dollars to somebody who's lying to me and not delivering what they promised. That's just silly.
Right.
So, yeah, it's. I don't know. I don't know what else to say.
I'm sorry you're in this situation. I'm sure you feel frustrated just as us. But
it's a new client. It looks like we pretty much this was one of the first batches they sent over to us in the same date that they hired us to do this. So this is some good information about this client.
Now, you also said that there was a 20% tack on that they were adding for the dispute charges. Is that right?
Yeah.
Because it sounds like they're trying to charge us.
English isn't the best.
Well, no, I think that they're
trying
correct.
To charge you for collection fees.
Yeah, exactly. That's what I was going to say. They're trying to charge us on the bill for what they're paying you to collect from us. I mean, I'm not even sure that's legal.
If it's collection charges of 20%, it is in there, Section 5.
Okay, in their contract. Yeah. Okay, all right. Then that's fine. But you can see,
as long as that doesn't exceed California law, then that should be. California has a legal minimum or maximum that you can charge, rather. So as long as that 20, it's whatever is obviously
the state law
smaller.
Sure, yeah. And again, that doesn't really concern me. We'll pay the money. I mean, not the dispute fees because they never responded. but we will pay the balance of what is owed when we receive the money that is due to us for the glass and for the insurance claim.
Well, last time I spoke with you, the gentleman before you, the one that who was unprofessional from your firm, said that Texas Mobile Group commit they're going to replace the glass if we pay them. We talk about we ran over the map on this one. So basically,
Yeah, I went over it with him. Basically,
Okay.
they owe us 20 over somewhere between 22
Right,
to 2700.
3K somewhere.
Yeah, based on the weight of the furniture, whatever it's determined at, but it's somewhere around 3,000 pounds. So you're talking, yeah, $2,700. I can't possibly pay them $1,200 when they're owing me more than double that. And again,
Right, so
if
basically
they
you
would like to
cancel-
process, if they'd like to process the insurance claim, they can. We'll just pay them directly out of the insurance claim, and they can send us the balance.
Right, and then they're saying because you didn't pay in full, I'm guessing that $400 that got disputed within so many times. I guess the only thing I can't really see is how much time they have to fix the glass.
It was
really
about
don't see.
yeah.
they have a long time. I
They
mean,
had
it's
the
well
glass
over a
vendor.
month.
Yeah, the glass vendor was waiting for them, and we had to continually pressure them and try and coordinate with the glass vendor to find out if they had heard from Texas Movers Group, which of course they continually didn't. And by the time we decided that we couldn't live without the glass anymore, it's a fine furniture table. It's of course I've said this again. It's an antique French style table, and we have 3 small children, so the table is getting ruined as we eat at it daily. So after a month, it may have even been 45 days, my wife and I decided, you know what, we can't just wait for them. Let's just replace it because they're not responding. So we did. Well, not that they're not responding, but in the end, basically decided they're not going to go through insurance.
Right.
So, I mean, it's whatever is convenient to them at the time is what they're going to tell you.
I got you. Let's see.
So yeah, I think that 30 to 45 days is plenty of time to replace the glass, especially since the vendor measured it, gave a quote, and was waiting for their actually, that's all they were waiting for. They were waiting for Texas Movers Group authorization to proceed, which they never got. And it's very frustrating because we actually finally said, go ahead and proceed, and then the glass company was too busy to do it. So we had to it took us 2 weeks to find another glass manufacturer who could provide us with the table.
So
Gotcha.
anyway, that's a story about the glass. And then when I dispute the $420, because of, like I said, Thumbtack cannot get hold of them. They're not responding to Thumbtack either regarding either the glass or the overcharge of $420. So I went ahead and dispute the $420 overcharge. And from that point, they also have, I want to say 90 days. Either 60 or 90 days. A long time for them to respond, of which they didn't.
To respond to Wells Fargo saying that we disagree with the dispute that's being made.
Right.
So they had no response, so it was ruled in our favor.
Right.
So we're talking about a considerable time that's passed here. We're talking about 30 days from the glass time that they declined. Then we disputed, we tried to resolve the $400 overcharge with Thumbtack, their, I guess you'd call it a contracting service. There was no dispute.
Like a lead service or something.
Yeah, there was no resolution availed there. So we disputed. And then from the point of dispute, which again is 30 to 45 days after the glass opportunity that they had 90 days to come back to Wells Fargo, either 60 or 90 days to come back to Wells Fargo and say, we disagree with this $400 dispute because, and they did nothing. Instead, at the end of the whatever time period it was, they canceled the insurance, which at that point put them in breach of contract. They were already in breach of contract for the $400 overcharge because we had a signed firm binding quote from them. So they breached that contract. Then they breached the new contract when they didn't deliver the insurance. So at that point, I told my wife, and this is where it got complicated, we need to call Wells Fargo back, and Wells Fargo didn't even want to dispute the remaining $1,200 because they said you can't dispute the same thing twice. And we had to explain to them, this is not the same dispute. There's two different issues that are being disputed. One is an overcharge of $426 or whatever it is. The secondary dispute for the $1,200 is because they are now failing to deliver services.
Which they have, like I explained to you earlier, they already escalated in technical court, which the legal department already basically determined the cost of the dispute is the failure to render services from them.
Gotcha. Okay. All right. So I thank you so much for the explanation and everything. I think I understand a lot more about this. And sorry it took me so long to get back to you. But yeah, I can, explain that to them. But like I said, probably, going to end up just closing the file. But I just wanted to, the client, ask that I talk to you guys one more time about it and explain it from what they tried to explain to me. Again, some broken English here, so it was hard to get that. But I think I understand exactly what happened now. Yeah, I'll just, it's very confusing, like how they do that bait and switch deal or whatever.
Yeah, and again, it's not just our
the
word.
original agreement?
Do we have the original agreement?
They gave it to you, right?
Did you ever get that to us?
I think you have
I think they did, because the person I talked to from your firm
was reading us
was reading us the
contractual
contract,
language.
and that's basically what it was. But anyway.
If you have, do you have a?
Yeah, I think I do got it here.
Okay.
Looks like it's like a blue word lettering and stuff. Okay.
Yeah, I think so. Ours is it should be a carbon copy. I think ours is pink with blue writing.
Okay.
But that was a contract we signed at the spot after the increased $420.
If you'd like, we have.
So anyway, just so basically that was a contract that we signed after they have increased $420. And again, I'm sure you can see your client basically is fraud, and I'm sorry you're in this situation. I think the best solution for you is just have them to talk to Wells Fargo directly. Basically, I mean.
Well, I think that they are talking to Wells Fargo, but Wells Fargo is finding their claim not substantiated. I think that might have been why they came back to you, or maybe waited to respond if that was the case. I don't know if they did or didn't, but I know they've been communicating with Wells Fargo.
Because I did notice that the additional $400 was saying that there was, like, I guess, a heavy item or something that wasn't listed, but I see on here two double desks, or two quantity, and then the description is desk double. So I don't know if that's what they were trying to charge you for, was the heavier items, but they didn't even move them.
No, yeah, that's the whole thing. There were several that were not moved, and they wanted to charge more. What they told us on the spot is that one of the desks that they quoted us, one of them, is all they cited. They thought the legs would come off, and they don't, because it's an antique desk. And so it takes up more room in the truck. That was their reason behind charging more. Even though we were moving less furniture, because they couldn't take the desk off or the legs off of one desk, they had to charge us more. But there was a person from their firm who came over and did a visual inspection personally of all the furniture and gave us a binding quote. So that should not have been an issue.
But it looks like they were just trying to hire you guys or whoever they can get help from, just to harass us.
Basically to intimidate us into paying.
Yeah, to harass us. Or I'm sure you understand that it's just a waste of time for you guys as well. But they have time to respond to Wells Fargo, and I'm sure if they're legitimate, they will get the money back. Wells Fargo is not going to let us just dispute it whenever we want, you know. So
Yeah, that's the whole thing. They have the opportunity to substantiate their claim, but they're not.
Right.
So I don't know if that tells you anything, but it certainly tells us a lot.
I mean, I've seen it go. I mean, where you dispute something, I've seen it go either way. Where, I mean, a lot of times the client's so busy they don't have time to follow up on the disputes or respond in the amount of time that they're given.
It doesn't seem like that's the case here because they're putting in a lot of effort with you.
Well, yeah. Well, I mean, it took me almost 30 days to finally get to the bottom of halfway understanding what they're presenting here.
Sure.
And I understand a lot more now that you've explained everything for me a lot better. But yeah, I mean, I'm pretty sure I'm just gonna close the file. Client's not gonna be happy about it. Like I said, they're a new client, but I don't want any trouble from you guys or anything like that. But you know, I appreciate you working with me on trying to make heads or tails of this. But yeah, I think I'm just gonna close the file on this one.
Yeah, we're not looking for any trouble. I'm sorry?
Do you have a collection agency for your business?
yes.
Yeah, we do.
You should let us have a crack at a few.
That's a real good sales pitch on the flipping that around. We're in. I don't know if you have California-based collection. Do you?
We do all over the United States. We're licensed in all the states that we need to be licensed in. We mainly do commercial collections. I don't know if you've got other businesses that owe you money. That's what we specialize in.
Yeah, that's what we do. We usually use attorney recovery services.
Oh, okay. Well, what do they charge you?
That I don't know. I would have to talk to the accounting department. We're not huge, but we're fairly large. We have a little over 50 people, so that's handled by the accounting department. But I know we use attorney recovery services. But we usually with a threat are able to get payment after 90 days. We go, hey, 90 to 120, we're gonna need to send you to collections, and we usually get payment. But
yeah, well, with our commercial collections and everything, you know, we've got attorneys in all 50 states. We even got one in Ontario. And so what we'll do is we'll send the demand. If they don't pay, then we'll actually file a suit against them. And then once we get a judgment, we'll go garnish their bank accounts or go pick up their assets, sell it, auction it, and apply it towards your balance.
Sure. If you want to send me some information, I'd be happy to take a look at it.
Sure, yeah, I can get one of our guys to send that information over to you. Talk to you a little bit more. What's the name of your company? Environmental. It shows up.
It's environment. The legal name is Environmental Treatment and Technology Inc. But the DBA is Advanced Technology Laboratories.
Okay. So is that like the medical field or?
It's environmental testing. So for any contamination in air, soil, or water.
Oh, like asbestos and stuff like that?
Similar, yeah. We don't actually do asbestos, but it's the same type of work. If the bank is doing a property transfer, then they'll want to test to make sure that the loan they're giving is on clean land, that sort of stuff. Or, you know, real estate development, they want to make sure that it's going to be healthy for families to be living at that site.
Yeah, no radioactive material underneath, or
yeah.
I guess I've seen somewhere where they'll like fill in a landfill and then build homes on top of it.
Yeah, that's exactly the type of work we do. We do the testing beforehand, and sometimes they will build houses on the landfill if they've done proper environmental impact reports and make sure that there's no contamination leaching above ground. And they'll monitor through wells. They put wells in the entire site. They'll monitor that for 30 years. to make sure that...
For the methane that it releases?
Not just the methane, but the other contaminants. They'll check the groundwater around the area to make sure that there's no leaching lead or arsenic from batteries and other things that may have gotten thrown away in the landfill. So those sorts of things.
Gotcha. Yeah, and I've heard like the tires will float to the top and stuff. It's pretty crazy. Okay. All right, so interesting. But yeah, I think I'm going to close your file here, unless they just offer some type of amazing explanation that, just, totally blows out of the water. But I seriously doubt it. It looks like you said, there's the multiple postings and everything, their little tactic of charging more and stuff like that. But I think we're just going to cancel this and give it back to them and let them know that we don't want to work this, because again, we specialize in commercial. Retail's not really our thing, and there's a lot more laws and stuff that we have to abide by that we want to be careful with. So and I apologize, Skylar was unprofessional with you guys. Again, sometimes working commercial accounts and then working a retail one, you got to be tread a lot carefully. So I apologize for that. But like I said, I'm just going to close your file here, and I'll get the sales guy to reach out to you about our services, and maybe you can throw him a little tester account or something like that and show you what we can do on commercial.
Sure. Yeah, I'd be happy to take a look at that. We're lucky that we get most of our clients to pay, but I do know there was one that we sent about 2 years ago that we sent them to collections for $36,000. So that probably would have been a good one for you guys.
Yeah. Have they ever paid it, or you already sent it over to an attorney?
No, we sent it to the attorney, and it ended up 1.5 years because the same type of thing. It was a gray dispute, kind of like this, except we were able to substantiate it. It was just endless, but we substantiated it, and in the end, the client paid. So,
okay, good.
That's why I said I'm very familiar with with this process that we're going through. Just not from this end, but I know all the tactics they're trying to use.
Yeah. Well, I just, with retail, I mean, they might be using a tactic here. We don't try to use any tactics, obviously, with retail accounts. I just
I understand.
Genuinely wanted to try to understand both sides. Obviously, there's two sides to every coin, and then try to maybe, if there was a settlement offer, we could do to resolve that, whatever, see where we can land, right? But yeah, I definitely understand your position and stuff. So like I said, I think I'm just going to close this file here, and then I'll try to get somebody in touch with you about, maybe collecting on some of your uncollectibles.
Okay, all right, that sounds good. I'll look forward to that then.
All right. I appreciate your time. I hope you guys had a great holiday couple weeks here, and hope you have a prosperous Happy New Year.
Thank you, Blake.
Thank you.
You too. You have a good one.
Bye-bye.
Bye-bye.
All right. Y'all take care. Bye-bye.